wanyonge wamepata haki zao, na ikiwa sisi hatuwezi kulinda, haswa wakati huu kuna community land registration inaendelea, alafu wengine wanataka kupora kutumia kwa njia isiyofaa, basi sisi tutaumia zaidi. Hiyo ni sio kusema ya kwamba sisi tunakataa donors ama investors katika ardhi zetu, lakini tumesema NRT wakaa kando kidogo mpaka tupate land registration ambayo katiba sasa imetupa.
The court observed whether the public participation was sufficient to meet the test is a question of fact. We agree that the Constitution must be interpreted holistically as was held in CCK and others versus Royal Media Services and others. Under Section 36(2) of the Community Land Act, an agreement relating to investment in community land can be made between the investor and the community. Section 36(3) provides that no agreement between an investor and the community shall be valid unless it is approved by 2/3 of adult members of a community assembly meeting called to consider the offer and at which a quorum of 2/3 is met. This requirement is replicated in Rule 22 of the Community Land Act Regulation 2017. The first respondent has stated that Cherab Conservancy is one of its 43-member conservancies, which is fully operational and has commenced the construction of rangers, outposts, and headquarters offices, which will serve and benefit the members of the marginalized communities. Further, the first respondent has averred that there was adequate and extensive public participation on this project with the members of the community before the commencement of the project, including the preparation of the EIA assessment report or study by followed by a NEMA license as per Annexure TL1 and 2 and 4. On their part, the second and seventh respondents through their deponents did not address the question of public participation, let alone its effectiveness, modalities, timelines, particulars, participants, and or reports before, during, and after the first, third, and sixth respondents started and operationalized the setting up and commissioned the establishment of community conservancies in Isiolo County in general, and in particular in Cherab and Chari wards in the year 2020 up to the filing of this petition. The only issue that the second respondent commended was a public participation during the presentation of the County Assembly Bill. The petition was filed on 4th of October 2021. Filed its replying affidavit in response to the petitioner's further supporting affidavit, the first respondent adduced TL1, which is a certificate of registration for Cherab Conservancy, which indicates its date of registration as 28th of May 2021. TL2 was the community awareness documentation setting out details of alleged meetings, which is dated the 5th of January 2023. TL3 was an EIA report for the proposed Cherab Conservancy. The report that was supplied to the court was, however, not signed and dated. TL4 or Annexure TL4 is the NEMA license, which was issued on 18th of November 2022 for the construction of Cherab Community Conservancy Headquarters. Under Section 31(1)(e) of the Wildlife Management and Conservation Act, the Cabinet Secretary, in consultation with the competent authority, is required to gazette areas zoned to have a wildlife conservation and management as their land use priority. The section further provides that such an area cannot be gazetted until the relevant provisions of the Environment Management and Coordination Act have been complied with and public participation has occurred. Section 58(1) and 2 of the MCA requires that any person being a proponent of a project shall, before financing, commencing, proceeding with carrying out, execution, or conducting any undertaking specified in the second schedule to the Act, to submit a project report to the authority and also undertake a full environment impact assessment and a study report. The evidence by the first respondent through the aforementioned annexures were all prepared after the petition was filed, but more importantly, the documents do not address the issue of creation of conservancies in the sued lands as required under the Wildlife Management and Conservation Act and the Environmental Management and Coordination Act. Equally, there is no evidence tendered that the second and eighth respondents facilitated public participation relating to the nature, extent, benefits, and impacts of the establishment and running of wildlife community conservancies in unregistered community lands in Cherab and Chari wards. There are no records that were undertaken by the state agencies showing meetings, press conferences, gazettement, briefing of members of the public via barazas, and structured questionnaires concerning wildlife community conservancies in community land before October 2021 when the petition was filed. Additionally, there has been no disclosure of any approvals from the relevant bodies authorizing the first respondent to establish a conservancy. There is no evidence of an environmental impact assessment, environmental social economic impact assessment, economic social impact assessment, or any feasibility study conducted prior to the establishment of the conservancy, despite the fact that the same is bound to interfere with the community's ability to continue with their social and economic life as pastoralists. It is therefore the finding of the court that the first, second, seventh, and eighth respondents breached the principles of public participation, which is a constitutional imperative under Articles 10 and 69, 1, D, E, and F of the Constitution. The petitioners have further complained that the first respondent, working as an umbrella group, together with the third to sixth respondents, established and is running community wildlife conservancies in unregistered community land within Isiolo County without express consent, approval, authority, or mandate from them and the community at large. In response, it was asserted that the first respondent is a non-profit members organization and that the rights of the petitioners to the land rank equally with those of the third to sixth respondents and indeed other community members who wish to adopt conservancies as a legitimate land use for the collective benefit of the community.
We now summarize our findings and conclusions on the issues framed for determination as follows. 1. It's our finding that the petitioners have the requisite local standard to institute this petition on their behalf and on behalf of members of Merti Sub-County, Chari and Cherab wards in Isiolo County. 2. We find that the petition before the court was pleaded with sufficient precision, setting out the nature of petitioners' alleged violations and meets the constitutional threshold set out in the Anarita Karimi case. 3. We find that the petitioners did not, in instituting this petition, breach the doctrine of remedies. 4. We find that the petition raised justiciable issues, controversies, and significant questions of fact and law, whose resolution lies within the ambit of the Constitution rather than statutes. 5. We find that the second and eighth respondents have breached their constitutional and statutory mandates by facilitating, or rather by failing to facilitate, the registration of the unregistered community land in Chari and Cherab wards, Merti Sub-County in Isiolo. 6. It's our finding that the establishment of the conservancies in the unregistered community land in Chari and Cherab wards has been undertaken in breach of the constitutional principles of public participation as enshrined in Articles 10 and 69, 1, D, E, and F of the Constitution. 7. We find that the first, third, fourth, fifth, and sixth respondents are conducting activities relating to community conservancies outside the constitutional and legal frameworks and have, as a result, infringed and violated the petitioner's constitutional rights, including but not limited to property rights. 8, we find that the existence and operation of armed rangers in the conservancies in Chari and Cherab wards under the management of the first respondent are illegal and unconstitutional. Ultimately, the court finds that the petition is merited and proceeds to issue the following orders. 1, a declaration does hereby issue that the establishment of conservancies in Chari and Cherab wards, Merti sub-county, was undertaken without due public participation and is consequently unconstitutional. 2, a declaration does hereby issue that Cherab Community Conservancy, operated and chaired by the third respondent, and Bulesa Biliko Community Conservancy, operated by the fourth, fifth, and sixth respondents, are operating illegally insofar as establishing and purporting to establish conservancies in Chari and Cherab wards, Merti sub-county, goes. 3, a permanent injunction does hereby issue prohibiting and forbidding the respondents, jointly and severally, whether acting by themselves, their agents, servants, representatives, assignees, and or umbrella bodies of the first respondent, from entering, mapping, surveying, and delineating, carrying out conservatory operations, including the recruitment, employment, or entering into any other forms of contracts, evicting community members, carrying out any activities, or in any way disposing the unregistered community land in Chari and Cherab wards, Merti sub-county. 4, a permanent injunction is hereby issued prohibiting the first, third, fourth, fifth, and sixth respondents, jointly and severally, whether acting by themselves or anyone under them, from operating or deploying rangers or guards to operate in any part of Chari and Cherab ward, Merti sub-county. 5, an order is hereby issued directing the second respondent to coordinate with the eighth respondent and the petitioners and offer necessary facilitation on the registration of the community land in Chari and Cherab ward, Merti sub-county, under the Community Land Act. 6, an order does hereby issue directing the seventh respondent to revoke any and all licenses and authorities that may have been granted to the first, third, fourth, and fifth, and sixth respondents related to the establishment and management of community conservancies within Cherab and Chari wards, Merti sub-county. 7, an order does hereby issue compelling the ninth respondent and the Isiolo County Police Commandant to oversee the implementation of the orders sought herein and to ensure that peace and order is maintained.
As you've heard from what the judge has said, we try to engage the local authorities, we try to engage the ombudsman, we try to engage the National Land Commission. So we tried so much. We did not just wake up and go to court, and that's why even the court ordered and made a finding that indeed we tried alternative dispute resolutions before coming to court. So coming to court was our last resort. Yeah.
We respect the new rule made by the court of High Court of Isiolo against our conservancy. But we are not satisfied as a conservancy the rule that was made against us. Because the rule which was made today, all those allegations are petty, mere, and called off. This is a matter to be settled back. We shall go into the drawing table and we shall go to win those who take us to court. Get us on your right face. We shall go to appeal against you right now.
Tunashangaa conservancy inasemekana imefungwa au watu wengine watatu wanalete malalamishi kwa koti ya kwamba ati conservancy sio nzuri. Hawa watu sisi tunajua ni wakora.
Insofar as the judgment has been delivered, a lot of effort has gone into it. In terms of the orders, we think that that decision for those who have been in this, that decision is extremely dangerous, if I may use those terms. And I say, why do I say that? Our main arguments in law and fact were that a conservancy is basically a unit of development right at the community level. It gives the community opportunity to come together, to mobilize, to use their land for development projects. Now, this case concerned two conservancies. In Isiolo, there were disputes around public participation. The allegations were that NRT, the communities, did not engage in a process of public participation that meets the legal requirements. We put in our responses. Unfortunately, the court did not agree with us. We have sought leave so the judgment to be stayed because we think that there are areas where the judges, with utmost respect to them, misdirected themselves. They have failed to appreciate the law. In a matter of environment of this nature, one should be very, very careful. We respectfully submit about the orders they make and the implications those orders will have. Now, from the conservancy movement, we made it very clear when we were highlighting our submissions that the conservancy movement preceded the 2010 Constitution. There were conservancies established before that, so that these issues that the petitioners, we say, weaponized to try and kill these two conservancies came even after some of the conservancies were existing. The other thing that we think the judges, again with respect, failed to appreciate is the role of KWS vis-a-vis the community in terms of establishing a conservancy. My understanding of the decision that the judges has made is that if KWS does not have a conservancy in its database or its register, then that conservancy is operating illegally. The correct legal position, as we believe and we urge, and we're going to urge if we're given leave to appeal, is that there is a huge difference between establishing a conservancy and registering a conservancy. The decision by the community to establish a conservancy is voluntary. KWS's function is to register. Now, there's a significant difference between registering and authorizing a community conservancy. The judges have taken the view, we believe erroneously, that it is actually KWS that creates conservancies or establishes conservancies. We think that is, firstly, with respect, not a correct interpretation, but more importantly, what effect does it have on the communities? So, we remain optimistic that in due time, these issues that we are articulating are going to be vindicated, and then the community conservancies in Isiolo and in other parts of the country can continue for the development and the benefit of the communities as has been going on.
Lakini tunaheshimu kotini. Ile maamuzi imetoa tunaheshimu. Na kwa amri ya Mwenyezi Mungu inshallah tutaapili.